business organizations, corporations, duties of stakeholders and common disputes. The business judgment rule shields directors and officers from liability by forming a presumption that they are acting in the best interests of the corporation. Directors and officers are not generally held personally liable to shareholders for corporate losses resulting from their decisions. Under the business judgment rule, courts refuse to review decisions made by directors and officers. There are exceptions where the director or officers were not acting in good faith, breached their duty of care, or breached their duty of loyalty. Directors and officers are duty-bound to undertake their corporate responsibilities with reasonable care. If a shareholder suffers damages, they may wish to bring a tort claim against the directors and officers. Showing breach of duty is necessary to break through the business judgment rule liability shield that normally protects directors and officers. As this is a tort claim, the plaintiff shareholder must show breach of duty, damages, and causation. The breach of duty by the officers or directors must have damaged the corporation and its share price, and the damages must be proximately caused by the breach. Under the duty of care, directors and officers of a privately held corporation are required to comply with the law. For a small company, this essentially means the directors and officers should avoid committing a crime that harms the company. They're required to attend meetings. It's not necessary for a director to attend all the board meetings, but attendance of some meetings is required. They're required to undertake reasonable investigations. This usually applies to mergers and acquisitions, where the board agrees to sell the company without checking the valuation and share price offered, that it's reasonable. Board directors today often commission fairness opinions, essentially valuation reports, to support decisions to sell the company at a certain share price. The directors and officers are also required to have a rational basis for their decisions. Virtually any rational basis will satisfy the courts. It's irrelevant whether there was a better choice open at the time. If some rational basis can be made supporting the decision that was made, the business judgment rule holds firm. The standard of what's expected of a reasonable director in a small, privately held company is not as high as the standard required of a director of a larger public company. The Sarbanes-Oxley regulations raised the bar, now setting minimum standards of care for directors and officers of public reporting companies, and provides for criminal sanctions by the state, as well as private tort actions by the shareholders. Directors and officers have a duty of loyalty to the company. They're required to act in the best interests of the corporation, not themselves. Conflict of interest statutes are now established for dealing with these situations in Delaware and many other states. They lose the protection of the business judgment rule if directors and officers breach this duty of loyalty by self-dealing or otherwise negotiating a transaction on behalf of the company, where they have a personal interest at odds with the interests of the company. These conflict of interest transactions are voidable by the company unless the interested directors disclose their conflicted interests and disqualify themselves from a vote or decision on the matter, and/or they show that the transaction is completely fair to the company. The business judgment rule protection can be regained if the conflict of interest is fully disclosed and the transaction is approved by the disinterested directors. Compensation of directors and officers is not generally capped or regulated in the United States. Businesses are free to pay their officers and directors whatever they wish. However, it would be a conflict of interest to have the CEO set his or her own salary. This is where the conflict of interest rules are applied, and a compensation committee made up of disinterested directors and committee members is required to set executive compensation in larger publicly traded companies. Compensation committees are commonly adopted in smaller companies as well. In assessing a fair market salary and compensation, the committee looks for comparables with similar positions in similar companies and takes advantage of the many benchmarking services available for this purpose. Directors and officers can be disgorged of personal profits they make on corporate opportunities. Determining what is a corporate versus an individual opportunity is not always easy, but several factors are considered by the courts. The first factor is whether the opportunity is in the corporation's line of business. So the president of a corporation personally buying and selling a yacht at a profit may be forced to pay the profits to the company if the corporation is in the yacht trading line of business, or a closely related line of business, and it would be reasonable to expect the corporation to trade in yachts. If the corporation is involved in an unrelated line of business, the opportunity to buy the yacht would not be considered a corporate opportunity, and the company would have no claim to recover profits from the transaction. Another factor considered when identifying a corporate opportunity is whether the corporation holds an interest or expectancy in it. So if the corporation was leasing the yacht, it had a property interest, and an opportunity arising to buy the yacht belongs to the company, not the president himself. The third factor considered is whether the director or officer learned of the opportunity in the course of his corporate duties. If the yacht opportunity was presented to the president at a company meeting, in the company office, this would point toward it being a corporate opportunity. If he learned of it while on vacation, it would point toward being an individual opportunity over which the corporation has no claim. To avoid any conflict in our scenario, the president may wish to disclose the opportunity to the board of directors and the other officers, and acquire the yacht only after the opportunity has been rejected by the company.